So I'm very delighted to chair today's panel on data, cross-border data transfer. And we have an all-star panel, not including me. So first we have on my left-hand side, Chen Li. She's a legal director leading a commercial legal team supporting Microsoft's China business operations and new developments. She provides legal advice and develops creative solutions to complex issues in new businesses, blending in China, cloud services, software licensing, and marketing strategy. And next to me is Richard Bird. He is the head of the Freshfields IP commercial and practice group in Asia with deep experience in commercial and transactional projects and contentious IP matters. And on my right-hand side, we have Mark Parson, who's a well-recognized expert in data practice, and he's now heading Hogan Lovells Asia Pacific Regional Regulatory Practice. And last but not the least, we have another leading female practitioner here, Sandra Liu, who's now the global head of privacy from the London Stock Exchange Group, with many years of experience in global data privacy compliance. Sandra, are you an alumna? Turn it on.
Yes, I'm actually a graduate from this university law faculty. So
you got your LLB from our faculty?
Yes, so I'm very glad to be back.
Oh, fantastic. Welcome back. What year did you graduate, if you don't mind? We wouldn't gauge your age, don't worry.
Yes.
Personal data, a good point. Okay. So we have, our panel have an hour and a half, and so we have plenty of time to walk through many interesting questions here. We will, instead of doing presentation like you usually see in this type of conference, we would do just short Q&A because I aim it to be quite, want to have more interaction between me and the speakers and also with you guys. So we'll reserve plenty of time for Q&A. So think about the question that you might have along our discussion. Now, data obviously is one of the hottest topics these days. And if you follow this area like I do, you will see an explosion of things happening in the data practice. It's just impossible to keep track of. And in fact, I am thinking about introducing a new course. Not thinking about it. I'm doing it next semester on data privacy and regulation in China. So just doing my promote here if you're interested in this area of practice. Now, but instead of spending a whole semester talking about this topic, I'm actually going to start by giving Richard a very challenging task, okay? You don't have a whole semester to walk us through the whole regulatory landscape like I do, but I'll give you 5 minutes. And you describe to us, what has happened with the regulatory landscape in relation to data practice, and particularly for today's topic, regard to cross-border data transfer, and particularly in relation to Hong Kong.
Thank you very much.
Okay, you can take off your mask if you.
I may do that. Okay.
Yeah.
Good morning, everyone. Well, thank you very much. There's obviously a lot of legwork to do in that first question. I'll do my best to get through it in the next 5 minutes or so.
Okay, I'm timing the clock.
Let me know when I get to 2 minutes. It's obviously a very complex topic, and there's many different facets to it. There's also a lot of terminology that people may be unfamiliar with. So we have critical information infrastructure, which is basically networks and systems, essentially that are of material importance to national security or national economic interests and the public interest generally. Also important data, which is essentially data. This is again of material importance to national security, national economic interests, etc. There is some overlap between those two terms. Formally, they are separate, but in terms of the sort of policy themes that they encapsulate, there's obviously some overlap there, which you'll see. And then we have personal data, which I guess people are more familiar with. The cross-border data transfer regime touches on all three of those things. So CII, critical information infrastructure, important data, and personal data. And there's various routes to get data out of China, which are regulated to a greater or lesser extent. So transfers of any amount of personal data by an operator of CII that has to go through a security assessment process and receive the approval of the Cybersecurity Administration. Similarly, transfers of important data, any amount of important data, have to go through the same process, also get approval of the Cybersecurity Administration. Now, when it comes to personal data, up to specified thresholds, and we'll look at what those thresholds are in just a moment, and they're quite low, but up to specified thresholds, it is possible to transfer data under a data transfer agreement, essentially. There are model clauses which will become mandatory once they come into effect. They've been published in draft, but they're not yet in effect. That said, the basic obligation to have a data transfer agreement is in force already. I think the appearances are it's not really being enforced, but it is in force. And then there is a system called certification, quite similar to the concept of binding corporate rules under the GDPR for transfers of data within corporate groups. Again, that system isn't really in effect yet, and the certification bodies have not yet been appointed. But then above those thresholds, again, you need to go through the security assessment process and get the approval of the Cybersecurity Administration. So those thresholds are of critical importance. And as I say, frankly, they are quite low. So the first threshold is the holding or the processing of personal data of more than 1 million individuals. I think anyone familiar with China will realize that's a very low number. Then there is, and by the way, that applies regardless of how much of that data you're actually transferring. So if you merely hold that quantity of data, you have to go through the security assessment process. And that's been enforced since the 1st of September. Then there is the cumulative transfer of the personal data of more than 100,000 individuals, essentially in the previous 2 years. So from the 1st of January of the year before last. Or the transfer of the sensitive personal data of 10,000 individuals, again, over the same sort of 2-year counting period. And again, that's already in force from the 1st of September. Now, that security assessment process still very unfamiliar to people. Applications are just being made for the first time now. We don't really have any basis to anticipate what the outcomes will be or exactly how the process is going to work. But formally, it's a 2-stage process. So there's an initial review, a formalities review, essentially, by provincial cybersecurity administration, then a more substantive review by national CAC in Beijing. It will look at things like the regulatory environment in the destination country, the security protecting the data, whether that's adequate, whether it conforms to Chinese national standards, also generally the risks of leakage of data or unauthorized access, that sort of thing. Exactly how it's going to work in practice, we don't know. Formally, it's meant to be completed within 12 weeks. Again, we don't know if it's going to take that length of time. There is, as you would expect, some ability for the authorities to extend in complicated cases, and we'll see how long it actually takes. Well, that's the sort of formality. Now, I said the system's in effect since the 1st of September. It more or less is. There's a grace period to the 1st of March next year, and that applies to companies that were already transferring data on the 1st of September and past any of those thresholds. So if you held the personal data of more than 1 million individuals and you had transferred any data before the 1st of September, you have to rectify by the 1st of March. Not really clear what that means, but it's understood based on commentary from officials that essentially you have to go through the assessment process, get approval by the 1st of March next year. Same if you pass the 100,000 threshold or the 10,000 threshold. You give me the side eye.
Yes. Hand it up.
Okay. Well, that's the essence of it. And there's lots of questions that arise from that, which I'm sure we'll sort of unpick over the next hour and a half.
Yes, indeed. I mean, I don't know how much you get it. I think after this 5-minute preview, you probably still need to take my class. So I remember last year when China promulgated its personal information protection law, the Wall Street Journal ran a big headline that China promulgated the world's strictest data privacy law. And obviously, China is not the first one to have data rules. I mean, EU is a very big player. One big question I want to pose to this panel is, do you see China as an exceptional player when it comes to data regulation? What features do you find is particularly distinct to China, compared with other jurisdictions? Yeah, Mark?
Sure, and I'll unmask myself a bit. So now Richard did a great job of presenting a very challenging regulatory environment. And I would just like to pick out a few factors of what he's described that I think are relatively unique. And I see this from the perspective of, we're helping clients with security assessments. We're facing those challenges very, very directly. I think there's a few things. One is, as Richard mentioned, not just personal data. We have this concept of important data, and that is a work in progress in terms of what that actually means. We have industry regulators, which are meant to be cataloging categories of data by sensitivity. And again, it's not necessarily personal data. So we have that dimension. We also have the dimension of cyber sovereignty. I think we can't avoid this issue, is that China's direction with PIPL, cybersecurity law, data security law, isn't just focused on, in as much as PIPL looks a lot like GDPR, you have to recognize that actually many of the provisions in there, the way they've been written with tweaks from GDPR, the way they're being interpreted, reflect China's vision of ensuring that its cyberspace is sovereign and secure. That's another dimension which we don't have with GDPR. So when we bring our GDPR compliance tools to these exercises, which is what we're doing, they help us.
Explain what is GDPR.
So GDPR is the European data protection law. And in many ways, it's sort of the gold standard of data protection law internationally. And it's got a long history. It's rooted in European human rights law. And so the difference here then is, again, PIPL looks a lot like GDPR. You hold the provisions up. Article 3 of GDPR looks a lot like Article 6 of PIPL. And, because of that, there's a temptation to see PIPL as China's GDPR, and it is to an extent, but the policies underlying it are different. And that's why when we come on to topics in more detail, like security assessment and so forth, you're going to see there's some differences there. You just can't apply the GDPR playbook. So I think those are sort of the main differences that I see with the Chinese environment versus what we're sort of used to here in Hong Kong internationally.
Sandra, you have anything to add?
Well, I think it's very difficult to be the second speaker. A lot of it picked up on. I think to me, the most difficult part of it is to ensure compliance, because a lot of it is the law come out and without guidance, without rules, and without specific detail. So
let me play a little bit different. We do have a lot of rules.
But as how to ground it for implementation, it's not particularly clear, because just imagine the cross-border security assessment measures is set to be implemented very soon, and given the very short time frame, and at the same time, the online portal is not ready. So the template, how it has to be done, the details, etc., the approval process, the operationalization, it's not particularly transparent to a lot of the organizations. So I wouldn't say it's unique in the sense that data protection is actually not just unique in challenging for implementation just in China, but also in many jurisdictions in EU, etc. The cross-border data transfer in the EU regime currently strands, etc., to ensure that there's adequate protection for the recipient country receiving the personal data is actually very challenging as well. So I wouldn't describe it as unique as such, but when it comes to the altogether, it's not just on personal data, but also on data itself as well. So, but when we look at the regime in EU, we do have a Data Act that is going to be out very soon, and then, but what will be in that act is that will it be the same as what we see in China? Actually, we don't have a very clear view at all at the moment. So I think all in all, it will be very difficult to say. Definitely, it is very unique, but the implementation process, the focus of the government might be slightly different from what we see in other jurisdictions.
Right. Yeah. So Mark and Sandra already mentioned some challenges when it comes to data enforcement. So let me turn to Trent. As an in-house expert, with so many rules in place this year, what do you think that are the biggest challenges facing companies with compliance these days?
Yeah, thank you for your invitation, Angela. I think why we are here, because we are Microsoft, we are a global service provider, cloud global service provider. So I think most important is, as Richard and also Mark and Andrew just mentioned, right? So there's unclear regulation and implementation rules is not issued, and especially for the important data. And also for if you didn't meet the requirements for security assessment by CEC, you need to maybe choose the SCC, the standard contractual clause, not be issued. The final draft had not been issued. And if you go through the security certification, the implementation rule had not been issued. So there's a lot of unclear ambiguity. If you want to choose one of the transfer mechanism when you do the cross-border data transfer. So we always receive a lot of customers' inquiry as cloud service provider, right? So can you help us to do the security assessment? And is there any information you can provide to us? I think the most challenging part, response to your question, most challenging part is for most of the company, whatever they are, multinational company, or they have a very big basis operation in China, or maybe they are domestic company, they go global, right? They are also using a large amount of the global cloud service provider services. So they are all thinking about how I can comply with this law. So the lack of the resources and knowledge, right? So their internal legal counsel, they may not equipped with the full knowledge. They need to consult with Richard, they need to consult with Mark, right? So get some professional advice. So and they also, their IT staff, and they don't have a lot of knowledge. So this is a training process. Actually, we can work together with the legal profession, with outside counsel, with our internal counsel. We need to discuss how we can work together to go through their self-security assessment. Even though you didn't meet the requirement, but you need to still go through your self-security assessment to do the data mapping, to just identify what kind of system or what kind of data you transfer cross-border, right? So this is most important and a challenging part from my perspective.
Right. I mean, do other panel speakers want to weigh in on this topic regarding the challenges, Mark or Sandra?
Well, while we look at not just China, but also Hong Kong, but also globally, because for global company, compliance is not just about one jurisdiction, it's about multiple. And actually, we have to build a standard that works globally. We can't bother the business and functions to provide information each and every time for a local compliance. So the most difficult part, I think challenging part, is to build a compliance program and also framework, or as Mark said, tools that work, perhaps not just for China, but also for while we build the EU assessment process, transfer assessment, et cetera. So I think that the complication when we look at data compliance, so it's not just one or two jurisdictions, but how to build a global standard that is interoperable, that can be used across different jurisdictions. So
Do you largely use the EU template at the moment?
Well, usually EU will be the global standard as we try to develop it, because while we see it, even though there are nuances between the different systems, say, for example, China's system and also the standard, we have a government-led security assessment standard. So what does it mean? Can we use the EU standard, say, for example, the security standards and also the technology compliance, Article 32 set of rules and standards to help organizations to satisfy perhaps the authority in other jurisdictions for the compliance. So this is something which a lot of the organizations are trying to push at the moment. So a lot of uncertainty, and perhaps that's the reason why we need good students, lawyers, and also participants and practitioners to engage in the conversation to find a solution.
Yeah, maybe just to highlight an example of what Sandra was discussing. When you transfer personal data out of Europe, it's actually quite simple at the moment. It's slightly more complicated than it used to be, but there's a set of standard contractual clauses. You need to sign up to a contract with your data recipient that imposes a number of restrictions that are directed at ensuring that the rights that individuals have in their data will be respected, even though the data is outside of the jurisdiction. Now and again, I'm old enough to know when those standard clauses first came out, I had many clients who said, these are crazy, you can never sign these. And flash forward, when you're as old as I am, people sign those clauses quite regularly. And there are some snags nuances we can get into about grams, but let's leave that out. I think the picture is still fairly clear, whereas with China's security assessment measures, yes, we have finalized measures that are effective as of 1st September. But what we've been doing, and this, of course, my team in Beijing and Shanghai, is we're really trying to unpick what the checklist is. When those case officers receive the application, what are they going to look for? What boxes need to be ticked? And we've done this in many other contexts to try to understand the new Chinese regulations as they come forward. But one of the challenges we have is we're getting different answers from different CAC offices on issues. We're getting very different understandings. The CAC in Shanghai has a very different view of how HR data is caught by these requirements than the CAC in Beijing, for example. And the other variable is just working with clients who, particularly ones in sensitive sectors who manage information security very, very closely. They worry that these requirements will oblige them to disclose very sensitive information about their offshore infrastructure. And that in itself is a challenge. And of course, we understand the overall objective of the security assessment is to understand, is the data secure? But GDPR doesn't go that far. GDPR requires the contract. It does require some assessment as to whether the contract will be upheld, but it doesn't require a deep dive into schematics of security systems in the offshore jurisdiction. So this is a big problem. We're trying to understand how much is expected here. Again, we're getting different answers, but there is a potential red line for organizations on this, where it's a security incident in itself, be disclosing their security infrastructure to a foreign government, and so that is a big difference to GDPR in Europe. And I think in practical terms, this is one of the biggest challenges we're facing at the moment.
You want to say something, Sandra?
Well, while we are on this topic, Mark, maybe I'll just add a bit so exactly what is required in the technical standards and the pack of information to be provided for the security assessment. So there has been some development on the multi-level protection scheme. Actually, when it first came out, and even at the 0.2 level, it seems not every infrastructure or IT system inside China has to be undergoing that sort of multi-level protection scheme. It's only level 3, then it's kind of compulsory. But then what does it mean when it comes to security assessment? Because sounds like the threshold now currently is quite low. I mean, in terms of the personal information threshold. But when you go through the security assessment process, does it mean that you have to provide a MLPS report or certificate of some sort, or filing records to the authority? So I think that's just to add to Mark's point about the uncertainty, the clarity that we need in order to make it work.
Right. I mean, a couple of the panelists already mentioned that uncertainty, the ambiguity. I mean, particularly, I mean, when I read these laws, I mean, there's a couple of big concepts like critical information infrastructure, important data, national security. I mean, these are key concepts that are never defined very clearly. I think there are some attempts to define it, but it's still very vague. And I wonder, in practice, how do you not, advise your clients to navigate this ambiguity? I know it's probably frustrating, but how do you deal with it given this is the reality? Richard?
For me, well, it's certainly a challenge. I'm glad to hear Mark comment that he's getting sort of contradictory answers from different branches of the CAC. That's our experience as well. There's key questions that arise, in particular in relation to the thresholds, how they're going to be applied across the corporate group. Will they be aggregated? Will the million threshold be aggregated? Will the 100,000, 10,000 threshold look at all members of the corporate group and all the data they're transferring, or only the particular companies making the application? You'll get different answers from different branches.
When you say different branches, is it from different regional office, or is it from different branches within the Beijing?
Well, in particular, there appears to be a schism between Shanghai and Beijing. You'll get very confident answers from Shanghai, and you'll get completely different answers that are equally confident from Beijing. Beijing, of course, is the senior regulator, and
the type of statement.
Yes, I mean that's the sort of national bureau. They have told us they will be speaking to the Shanghai provincial branch to correct their interpretation, see if that achieves alignment or not. So a lot of uncertainties. When it comes to important data, honestly, and perhaps one shouldn't be too honest around a topic like this, but all appearances are that system is not really being enforced at the moment. In essence, it can't be enforced because no one knows what important data constitutes. There is some limited guidance. It's mainly directed actually at the authorities that are supposed to be coming up with the more detailed catalogues. It is somewhat useful. It gives you some idea, but there's a lot of construction, a lot of interpretation required. Critical information infrastructure, that system works basically by way of individual designation. So you wait for a tap on the shoulder, as it were. That itself is not particularly surprising. The system in Singapore works in a very similar way in terms of individual designations. And in terms of sort of why these terms have not been defined, they obviously arise in a particular geopolitical climate. They advance policy goals that are not sort of purely economic policy goals. They are, to some extent, geopolitical policy goals. The system isn't, the most important feature of the system is not necessarily to give clarity and certainty to economic operators. I could put it that way. There are broader policy considerations at play. They're also quite difficult to define. And so one can understand why it's a process that requires a lot of discussion among different stakeholders in the Chinese government and will take some time to formulate. How we're advising clients, it depends from case to case, and it depends on what whether it's critical information infrastructure, important data, or some of these other questions around personal data. But it's never straightforward.
That's how you guys make a lot of money. So Chen,
I just want to supplement 2 points. I think Richard already said very, very well, right? So I think the first point I want to make is for the important data. So maybe because we are dealing different industry customer, right? So it's maybe they're in the retail industry, they are in the automobile industry, maybe they are in the manufacturing industry. So in their specific industry, so industry regulator, they have specific rules. So we always ask our customer to, maybe you need to also take a look at your sector regulation and implementing rules, and also consult with your sector regulators to get more answer. What kind of things, what kind of data will be classified, identified as important data, just like automobile mapping data, right? So if you collect any generated or collected personal information inside China, it's very sensitive data, right? So also the mapping mapping data, you need to use certified Chinese mapping service provider, right? So you need to sign this kind of contract. So it's a very complicated issues. I think another thing I want to point out is a lot of companies, they are using email, right? So email, you go through the Outlook and Office 365, you're using this kind of email service. Is there any data transfers to the email to your headquarters, or any customer or client overseas will be treated different? So we have a separate consultation with regulator, and seems like they don't think there's any big difference. You still need to go through the review and approval process. But what we get from the authorities, they don't think the multinational company, their internal email correspondence, like headquarters or their Chinese subsidiary email correspondence, or they think their internal business operation data, they don't think this is mainly focus or primary focus from their perspective, right? So like Richard said, this is a national security issue, the important data issues, but they don't think that this kind of internal multinational business operation transfer will be treated as primary focus from their perspective. Of course, there's no official guideline, right? But I just want to supplement. And also for the email, it seems like GDPR also have a similar concept, like unconstructed data, right? This is kind of unconstructed data. You cannot search or just to find out what kind of data is important, especially for the cloud service provider. We don't have this kind of authority or access to our customer data, right? So our customer themselves, they may also serve another their and the customer. They also maybe don't have any access to this kind of information. So this kind of unstructured data under the GDPR and also even the US the privacy data protection law, right? So they don't have any different treatment to treat the unstructured email, the correspondence. This is 2 points I want to supplement.
Right.
Let me just come in. Thank you. Very, very important clarifications, and absolutely correct that there's a further layer of sectoral regulation we need to look at as well. And there are some quite surprising positions taken as regards important data in some of those regulations. Despite what I said about the system not really being fully enforced, clients, of course, are tiptoeing around important data with great care because of the national security dimension to it, and in practice looking for ways to avoid making a transfer of anything that may be considered to be important data, and that's in somewhat sharp contradiction to or distinction to attitudes to personal data, where I think there's somewhat more of a risk appetite, recognizing that given that the system does apply to some very trivial intergroup transfers, and a lack of clarity about the availability of some of the exemptions, again, contradictory guidance coming from different regulators. Clients are somewhat more willing to take a more robust view around transfer of personal data, but are being particularly cautious when it comes to important data. There's also one further concept that I didn't touch on of core data, which is briefly mentioned in the data security law, briefly mentioned in the draft implementing regulations. It appears to be even more important data. The guidance is extremely scanty. But that is subject to a complete export ban. There is, in essence, no way to get approval to transfer that data out of China. So again, with that overlay, there's good reason to be cautious when it comes to important data and whatever core data may be.
Yeah. Right. I mean, one company that wasn't that cautious last year was probably Didi, when it decided to go listed in the United States without going through the cybersecurity review process. Although at that time, this whole process was very new, and that's probably what our audience was very familiar with. But after this Didi incident, the Cyberspace Administration of China introduced a security assessment regime, and this is separate from the cybersecurity review regime. And Richard already mentioned that briefly at the beginning. I wonder if Mark, you can walk us through a little bit about what exactly is this thing?
Sure. Well, I don't think I'm going out on a limb with the other speakers to say that we don't quite know. But it still leaves the question for, well, how do we help clients with this data security assessment process? Because you're also hearing a sense that, look, many organizations feel there must be something real to this. There's something there. There is a law that people do expect at some point will be enforced in some way. there was, why is it there? So let's start with what we know. And what you're hearing is we don't know a lot, but we are drawing from tools we've used elsewhere. And I think the first step that we invariably recommend to clients is a data mapping exercise, just to understand factually, well, what data are you sending offshore now? Because that at least forms a perimeter of what could be relevant to you in terms of compliance. And we actually use, it's interesting, we've taken our GDPR tools for that. So we have the data inventory questionnaires, and these are Excel spreadsheets that, and if you're on the receiving end of one of these, you're not very happy because it requires you to sort of list out all the types of data that you're processing, what systems is it in, did you collect it, what is it being used for, what is the retention period, and breaking it down into some of the, the categories that Richard's mentioned. There are sensitive categories, there are categories of important data. And so the spreadsheet, gets to be quite large, but the benefit of doing it is that at least then gives you the facts, because at some point this thing will become real. We think it is already real for a number of clients, partly because they're industry regulators, partly because of pressures from their partners in the mainland. But then you've got the facts. And so once you have those facts, then you can go about assessing the threshold. So the security assessment review is triggered by having 1 million more data subjects in total, irrespective of the size of the transfer, 100,000 data subjects for transfers generally, and then 10,000. So this is over a rolling period looking back to the previous 1st January, bit of a complicated rolling period. But you look back between wherever you are in the previous 1st January, and you look at how much data you've transferred in that period. 100,000 data subjects generally, 10,000 with sensitive personal data. And what we've had, the other benefit of doing this inventory exercise is we've had a few clients who said, well, actually, do we really need this data? Do we need to be transferring this offshore? And this is just good data protection practice generally, frankly, is to look at your data retention periods, look at the data you have, because if you have it, it's a security risk. It could be hacked, it could be lost. And so one of the positive aspects of the inventory is not only preparing yourself for the security assessment, but also just doing a good housekeeping on data. So the data inventory exercise, we definitely recommend, and assess the thresholds, look at, should we be getting rid of certain data? Do we need to transfer it? And then you get the task then of, well, what do we submit to the authorities if we are over the thresholds? And that's where we're involved in a number of these where it's very slow going. We do feel the authorities haven't been fully briefed on what they're expecting. And the typical areas that we see clients very, very concerned about is not so much what I described, disclosing, well, what data is going offshore. That's actually fairly easy. The difficult part, as I alluded to earlier, is how do we persuade the authorities that once it reaches the destination, it is secure in accordance with Chinese standards. And that's where we're in a lot of back and forth with the CAC, trying to judge, well, how much do we need to be disclosing about the security environment where the data is going? Because part of that feels like under GDPR, there's something called adequacy, where you look at the legal environment in the destination. You look at the laws, and are they adequate to protect data? But part of it too is very technical and practical about the information security environment. That's the big worry area for many of our clients, where they feel we don't disclose that to anyone, not to our home regulators. And if we disclose that to the Chinese authorities, that's going to cause anxiety for our customers, for our stakeholders, our regulators in the home jurisdiction. So maybe I'll stop there. There's a lot.
In my last life, I was an antitrust attorney, and what we mostly do is advise clients to obtain clearance before they go ahead with the merger transaction. Now, it looks like what you described is similar to merger clearance process, that before you go with a very big transaction like an M&A, or even like in the DD case, like go overseas listing, you need to get clearance, data clearance from relevant authority. Although I don't know whether the CAC have insufficient capacity to deal with all those requests and handle it in a very efficient way, right? I mean, so I wonder, Chen or Sandra or Richard, would you give us a little bit examples? I mean, in practice, how do you go through this data assessment process? Is it a very big hassle?
Yeah, let me chime in first. Maybe Richard, you can. So I think most important things is one concept we need to take consideration is who is data controller, who is data processor. So this is very important. For example, like Microsoft, we may no need to consider about customer data. We are processing stored for our customer during when the customer using cloud service, right? So what we need to consider is HR, human resource data, because like a lot of multinational company, they're using HR system. Their vendor maybe sitting overseas in US, right? So it's like not only Microsoft, but also another multinational company. A lot of data, personal information collected from their employee maybe need to transfer outside of China because they are using the HR system, right? So this is one factor they need to consider. So who is data controller, who is data processor? If you are data controller, you are eventually subject to this kind of compliance obligation, right? And also, when you do the analysis, you need to consider if you're doing marketing campaign, is there any information collected during this kind of marketing campaign will transfer out of China, right? So I think also if you sign the contract with your customer or the end customer, you collect some contact information from the customer. So this kind of contact information may be transferred out of China. So this is basically from this concept, you need to really go through very detailed data mapping, like I just mentioned, right? So to just establish what kind of system, what kind of data will be transferred outside China when you're acting as data controller. Like the data handler is the same concept under the PIPL. And another thing I want to mention is you really need to identify which data transfer mechanism you will use, like Richard just explained, right? So there are three ways. So one way, the security assessment led by CC. Another is standard contractual cost, sign the standard contract at CC, right? And another one is security certification. So you really need to consider your own situation to just identify which transfer mechanism you will use for your enterprise. And then you will work together with your overseas data recipient to just get all the information about data overseas data transfer, the channel, and which data processing role you will go through, and what kind of data you will go through to outside. So this is a very detailed plan. You really need to work together with legal profession and to go through yourself security assessment before you make decision which way you will choose. Yeah.
Richard, do you want anything to add?
Well, I can comment a little bit on the impact of the cybersecurity review for listings. We have some experience of that from our IPO practice. That said, I mean, the Didi decision has had a somewhat chilling effect on the market generally. So there haven't been that many successful IPOs over the last 18 months. But to the extent, there has been experience there, it does appear to be generally accepted both by the authorities, but also by the exchange, that this cybersecurity review process does not apply to a Hong Kong listing. The exchange and sponsors are generally happy to put on legal opinions to that extent. Some sponsors will want that tested case by case with the authorities, but the general consensus is that Hong Kong is not considered to be an overseas country, foreign country for these purposes. There is, however, a further security review process where the listing may have a national security implication. That is formally not yet in effect. It's in draft implementing regulations. As people that have experience with China will know, that doesn't always necessarily mean that will not be enforced. And there is some nervousness around whether that will be, or how that will be applied. It will apply to a Hong Kong listing. But there's, again, no real clarity as to what may be considered to be or have implications for national security. When it comes to that, as I say, it's still formally in draft. Some listing applicants are approaching the authorities for confirmation assurance that they will not be required to go through that review, or it will not be applied to them retrospectively, as was essentially the case with Didi. Others are preferring to not ask the question, if I could put it that way.
Sandra?
Law, yes, are all there, but what about compliance? So a lot of times when it comes to compliance, we have to think about a granular scheme, and cannot do it on an ad hoc manner. So I agree with Mark that we have to be very clear about, and also the other audience about, who are the controller, and when it comes to data classification, mapping have to be done. But it all comes down to a program, what we called the compliance program, the data privacy compliance program that we built in an organization. It is actually quite a complicated matter that cannot be explained in just 3 minutes or 2 minutes, but it would have to be tackled at multiple fronts. How you look at your vendor, how you look at your customers, where you transfer the data, allow that data to be transferred to your vendors. What would have to be put into the contract? There are clauses, as Mark said, standard contractual clauses, where a set of protection clauses will be in place if you are dealing with a controller. And at the same time, we can't just deal with one single security assessment report. There can be multiples, and also at the same time, country risk assessment cannot be just one country. It has to be multiple countries and jurisdictions. So when you look at the whole grand scheme of things, you have to build a framework and try to tackle it at sourcing, customer, contract, mapping, Excel, and then try to understand the different classes of data and apply it according to the principle being published, which is yet to be interpreted, and then try to make sense out of the level of sensitivity and criticality. So this is a kind of program. Somehow, when you come to a point of time, it cannot be manual. It has to be perhaps automated and annually set up a process where you have to make sure that there would be a process for annual attestation by the business, perhaps by the different business functions like HR, marketing, etc., etc. So again, 2 minutes, very difficult to explain. There are certificates for data management. There are certificates for students to go to find out what a compliance program should look like. So much to learn and much to build.
Good. Richard, you already mentioned that for Hong Kong listing, kind of like an informal consensus has been formed that you don't need to go through a cybersecurity review. And actually, I do my homework. I look at the perspective of the company that for preparation of today's talk, because I have no idea what the practice looks like, I never practiced data law. I look at the perspectives of all the companies who came to list in Hong Kong in the past 6 months. And I'm surprised to find that none of them filed a cybersecurity review despite the DD case. And all of them admitted there is this risk. However, we think we don't need to file. And I also took a look at the New York listing, and none of the companies filed either. So, despite the fact that, there seems to be a different treatment between overseas, real overseas and Hong Kong listing. So my question is, how do companies reach this conclusion that they don't need to file for cybersecurity review? Did they get informal assurance from the regulators, or was it the regulators just don't have the capacity to deal with this thing? I remember in the DD case, 7 regulators formed kind of like an ad hoc team to march into DD's office to conduct a cybersecurity review. I guess, if the review team is formed ad hoc. It's not like a routine practice. I mean, this thing cannot be like a routine assessment, right? I mean, so I have no idea what the enforcement is actually like. Yeah, Richard.
Well, we do have some experience with full cybersecurity review on a Swiss listing, in fact. And you mentioned capacity constraints at the CAC. That process meant to take sort of up to 3 months. Again, I think there is ability to extend it in complicated cases. It actually took more like 5 months. And for several months, it was a clear issue of a lack of availability of personnel at the regulator. They've been tasked with many other responsibilities when it comes to national security and cybersecurity, so they're clearly quite resource constrained. It was not a, how can I put it, a particularly transparent process. It was a process that took place at the highest level of the listing applicants management and involved very direct interaction between management and the regulator. It's not as if there is a formal set of application requirements or a formal set of criteria for the review, and you can draw your own conclusions from as to why that may be and what the priorities may be for the regulator. But it is happening. I don't know why it was not applied to some New York listings that you mentioned. When it comes to Hong Kong, it's a little bit more than just an informal consensus. I mean, there is a fairly formal exemption for Hong Kong, albeit in draft implementing regulations. But it is generally accepted that this will not be applied to Hong Kong. That said, national security review could essentially function in a very similar way with similar outcomes. Indeed, again, in the draft implementing regulations, there is effectively an equation between the holding of personal data of more than 1 million individuals and important data. And important data, again, has a national security dimension to it. So the threshold for going through full cybersecurity review, which is again 1 million data subjects, essentially equates to important data, which equates to national security. So you kind of get to the same place anyway, the Hong Kong listing. That process is not in effect yet. And to answer your question about how listing applicants are getting assurance, as I mentioned, some are approaching the regulators directly for that assurance, others are not. Most opinions issued to the exchange will simply note that system is not yet in force. So that's how it's being handled at the moment.
It's really difficult. I can imagine. I mean, how would the industry respond to all these ambiguities and uncertainty with China's data regulation regime? I mean, I don't know. Chan, would you like to weigh in? I mean, have you heard anything?
I think from industry perspective, we will see 2 waves. And one wave from some multinational companies. So they are, because we prefer using global cloud, right? So for their cross-border data transfer. So they are actively preparing self-security assessment by working together with outside counsel, by working together with overseas recipients like Microsoft, AWS, Google Cloud, right? So depends on which cloud they are using for data transfer overseas. So this is, we can see one of the trends. The other trend that we can see, because they are really worried about some kind of multinational company, they are dealing a lot of important data, like auto industry, right? Like some kinds of CIO, critical information infrastructure operator. So they are worried about maybe they can't pass security assessment like CAC. So they tend to transfer their global data. They're using global cloud services and migrate their data to the local cloud service provider, like Ali, Tencent, right? So like Huawei Cloud, and also for AWS and Microsoft, we also have our domestic cloud service provider in China. So they tend to localize and to do the data localization by using the domestic cloud service provider, CPM, right? So this is the 2 trends we can see. One side, they are actively doing security assessment, and one side, they are transfer data, migrate the data to the domestic CPS. Yeah.
Sandra or Mark, would you like to weigh in? Your mic.
Oh, sorry.
Lower your mic a little bit. Lower your mic.
Yeah, yep, agree with what was just said. The two trends, and I think what it means for Hong Kong and China eventually, and also to find a interoperable system, I think is a very key point, because it's not just between Hong Kong and China, but also the rest of the world. So when I look at this topic, harmonization, I feel that a more suitable term I would use is interoperability. And it's very difficult for two systems to be completely harmonized. So how to recognize the differences between these two, and perhaps with the rest of the world, and try to build an understanding whether the differences can be recognized. So because if not, then we don't want to see relocalization, and the flow of data is really key to organization. It's not just to facilitate the digital economy, but a lot of the activities which is particularly important for organizations like financial institutions. Say, for example, attacking AML, KYC, this sort of activities. We need the flow of data between jurisdiction with speed in order to give organization a one window and one-page understanding of what is going on about, say, for example, particular person or particular institution. So I think that's the backdrop that I would like to add.
Mark?
Yeah, I would just quickly add on this point that the need for clarity is urgent, and I think you're probably hearing that across the board here. And this is speaking as someone I've been here about 15 years now in Hong Kong, and right from my very first days, you get the question: we can't take our data out of China, can we? And 15 years ago, it was easier to answer that question. Look, for a long time, there have been particular types of data that are localized to China, map data, for example. There are specific laws dealing with that. More recently, we've had laws with autonomous drive cars. Those a specific set of regulations which localize that type of data. But in the main, you actually, apart from industry regulations, you could take data out of China. And what's slowly happened is we've had cybersecurity law, now PIPL, DSL, all these laws have added to that uncertainty without necessarily resolving it. And we spend quite a bit of time helping clients who are faced with a customer in China who's saying, no, you must keep our data in China. That's what the law says. And there are cases where that's absolutely right. Again, if it's mapping data or something which is localized, that's correct. But the sense I have now is that balance is shifting, where we used to win those arguments a lot of the time and get people comfortable. Of course, put in place a sensible agreement with sensible security around the data. That's a given. But the challenge we're getting now is a fear factor, a chilling of cross-border transfer, which I think is very unhelpful to, Sandra's mentioned some very good examples of where cross-border business, and for Hong Kong, I think this is very important. Cross-border business depends on the free flow of data. That's just a modern reality of business. And so I think the uncertainty in itself is very unhelpful to investors, to businesses, both sides of the boundary moment. So I think clarity is important.
Is there any companies that are doing particularly well in response to this change, or any type of market? Let me follow up with you. Some that struggle more.
Well, I think we're all struggling. I think struggling is there's no shame in admitting that we're struggling at the moment. But I think the organizations that feel more confident, I think there's two variables. One, they have an industry regulator in China who has been actively engaging the CSC to find solutions, and there are a few industry regulators who are doing that. And I think they feel for their stakeholders this is a good thing to do, to get some confidence that the practices and procedures they have that are long established are sufficient. And I think those ones, it's just a palpable difference when we get on the phone with them, because I think they feel they've been given a direction by their authority in China, their industry regulator, that, yes, this is fine. So those ones I think are in a better place. The other ones who are in a better place are ones that have been through the Excel spreadsheet before. The businesses that are GDPR compliant, businesses that are, I think in Hong Kong, probably the best example is financial institutions, HKMA regulated financial institutions. They have a lot of technology risk management regulation, a lot of regulation of customer data. And so they feel that, well, look, we're doing a good job. You know, we've got these, it's much higher standard than PDPO. You know, they're complying to high standards. So I think they feel no matter what happens here, we've got a good answer that we should be able to transfer data out because we've got all this infrastructure in place. But apart from that, those two examples, I think most organizations are frankly struggling with what might come from this.
Interesting perspective of our struggle. So let's finally switch our focus to Hong Kong. I mean, Richard already mentioned Hong Kong seems to have a little bit, enjoy some preferential treatment when it comes to listing. I don't know, does Hong Kong have received any other form of preferential treatment other than that in terms of data transfer, do you think?
Not formally. If there's any expectation that Hong Kong will not be treated as an outbound destination for the application of these rules. We may see practice developing in terms of the willingness of the CAC to grant approvals to transfers to Hong Kong. Whether that really materializes or not, I don't know. There aren't that many situations that involve purely bilateral transfers from mainland China to Hong Kong and going nowhere else. And the authorities in mainland China, of course, will be aware that there are very limited restrictions on further onward transfer of data from Hong Kong of any kind, including personal data. So no real expectation, I think, that Hong Kong will be treated differently. There are some limited proposals to allow enhanced data sharing in the Great Bay Area, particularly focusing on medical research data and other forms of R&D. That's all quite tentative at the moment, but we'll see if that materializes. I think Mark makes a very good point, on the other hand, that there's a lot of misperception about what the rules actually permit and what they do not permit. There's misperception both within domestic Chinese companies, but also international companies. Misperception as to whether or not these rules actually apply to Hong Kong directly. And international companies have formed the view that they do, or that they will be applied imminently. I don't think there's any real indication that is the case, but there is a general expectation among many international companies that will occur. And as far as domestic Chinese companies are concerned, again, similar to Mark, we hear very often a view that it's too risky to transfer our data, too risky to transfer our technology. We're not really allowed to do it. And even if we can do it today, we might not be able to do it tomorrow. So we just have to view this deal as a China for China deal and exclude the international component. So the uncertainty, much of which is planned and is strategic, is having adverse economic consequences. There's no doubt about that. Again, I don't think it's too controversial to say that these rules are not implemented to drive purely economic goals, but for broader geopolitical considerations. So that perhaps is a price that the Chinese government is willing to pay. But certainly the effect is very real.
Right. I mean, Zhang, would you like to weigh in this question as well?
I think Richard already mentioned there's no preferential treatment, right? So for Hong Kong, but we also heard some kind of conversation between Hong Kong and China government, right? So it's currently going on. So, but simply maybe in the near future, let's see if there any mechanism will be taking place. And also we heard from the third party institution, and they are just promoting third-party certification, right? So in Hong Kong, because Hong Kong really, we have more than 40 Hong Kong data center based in Hong Kong, and also we have more than 20 cloud service provider in Hong Kong market, and also based on the research report. It's over $20 billion market share in Hong Kong in the past year. So this is very big market. So we really want to see, especially for the global cloud services, we have data center in Hong Kong. Is there any way through the certification or through the one country system mechanism, we can get some preferential treatment from China government? So let's wait and see.
Right. I mean, to delve into this question more deeply, we need to understand what is the rule for cross-border data transfer in Hong Kong, right? I mean, because once your data comes to Hong Kong, you want to know what's the next. So Sandra, would you walk us through that first?
Go Section 33 of the PTPO. We do have a provision in law that governs cross-border data transfer, but it's not yet made effective. Now we still rely on the guidance to govern that framework. So it's yet to see the ultimate effect of it. But when you compare the mechanism and also how it compare with the EU and also the mainland regime, you can see some common feature like the whitelist. You can transfer data to whitelist jurisdiction. Definitely something you can find in the GDPR, and it's similar to country risk assessment. But then own assessment regime is another regime where you can see in the Article Section 33 of the PTPO. And then, well, this concept of self-assessment is also enshrined in the PIPL and also the GDPR as well. So common features, yes, but when it comes to the due diligence part of it is Section 33, subsection 2F, if I remember correctly. All right. The due diligence step being taken by organizations to ensure transfer of data will be given adequate protection. It is not particularly clear when it comes to the SEC being attached to the to the guidance at the moment, whether it covers equivalently the 4 module published by the EU side, and the PIPO, the draft SEC at the moment is 2 modules. So the regime in Hong Kong, how it developed, whether it will be officially implemented, whether it will move from a guidance stage to an actual implementation, whether it needs to be perhaps amended to a certain extent, say, for example, to explicitly recognize the certification, or perhaps to explicitly recognize SEC as the measures. Still, a lot of these will have to be considered, I guess, in the policy review and the review of the overall of the PTPO, which I believe the CMAB has made it quite public in the recent policy paper that they're going to look into it. And also the fact that there is a digital economy development committee being formed in June this year. I believe that it will drive a lot of the changes, which this sort of development committee will usually be the foundation in driving a lot of the data economy and data law changes in other parts of the world, so including China. So I believe that there would be some development in the law. So a lot to be seen.
Right. I mean, so as Sandra has mentioned, there seems to be very little going on in Hong Kong at the moment in restricting cross-border data transfer. And you have this provision in place, but it's not really implemented yet. I mean, Richard, can you tell us more about, what do you think is the prospect of Hong Kong tightening its cross-border data transfer? I guess that will put Hong Kong in a very difficult position, being, a leading financial center. You don't want to restrict data transfer. At the same time, you might want to have more harmony with the mainland regime.
Yeah, I mean, it's been to Hong Kong's advantage to allow fairly liberal data flows, and Hong Kong's been keen to promote itself as a regional data hub and a sensible location for data centers. I mean, that took a bit of a knockback after the enactment of a certain notorious law a few years ago. But otherwise, the policy in Hong Kong has been to permit cross-border data transfer. I don't really see that changing. I think, as Chen Li mentioned, there may well be some moves to promote the certification regime for transfers between the mainland and Hong Kong. That may be a relatively attractive route. There hasn't been much focus on it yet because it's not in force, but we'll see if that comes to pass. Ironically, of course, one of the reasons why Section 33 was not brought into effect was the whitelist is a bit of a political hot potato. Ironically, of course, China has leapfrogged Hong Kong in terms of its formal data protection standards. So successive commissioners have chosen not to tackle that issue for reasons that one can be sympathetic to. But if they chose to, I think perhaps there would be less controversy around that topic than there may have been in the past.
Right. I mean, that brings me to the question of what do you think that Hong Kong will continue to receive more preferential treatment from the mainland? Because if you don't see Hong Kong tightening its restriction for data transfer, I see it less likely for Hong Kong to get proper exemption from the mainland regime and enjoy more preferential treatment when it comes to data transfer from between mainland and Hong Kong. I mean, Mark, do you agree?
Yeah, I think that in general must be right. The PDPO, just to put it in context, so it dates back to the mid-1990s. It's been amended twice on a fairly selective basis, whereas China has suddenly moved ahead with PIPL, which again looks a lot like GDPR, the gold standard of international data protection regulation. So the gap is very significant, and it is difficult to see, however you want to call it, preferential treatment or an idea of adequacy of the standards here, achieving that status without Hong Kong's PDPO moving forward significantly. And as Sandra mentioned, that there's a white paper published back in January 2020 by the Constitutional Mainland Affairs Bureau, jointly with the Privacy Commissioner's Office, which did detail a number of changes which are planned for the PDPO. But again, these are fairly selective, and I don't think go to the root of the issues that we have on this question, which one is, as Richard had mentioned, well, there's no international transfer restriction. So data will come to Hong Kong and then move out. Of course, for many, that would be a great scheme to avoid the PIPL if Hong Kong were generally exempt and quickly we got things that we don't think that's right. But the other areas, if you look broadly at PIPL and why is it so much more of a higher standard than PDPO? There's a lot of things in there. There's an idea of data governance, of accountability, of having an organization-wide commitment, which is endorsed at a senior management level to ensure that data is handled in accordance with principles. And so there's a lot there. And the other dimension, going beyond GDPR, is the cyber sovereignty issue, which again, I think is a important differentiator for PIPL and for data security law, cyber security law in China, that you need to recognize when you sort of line up PDPO and PIPL. It's not just about looking at the European reference standards. So there's a lot to be. I think if the desired outcome is equivalency, adequacy, there is a lot of work, I think, to be done in Hong Kong to level up.
Right. I mean, Chen, would you want to weigh in that question as well?
I think another thing I want to just supplement is we can see very strong competition from other countries, right? So like Singapore, like Japan, Korea, right? So there is, of course, from the cross-border transfer perspective, there seems like no different, but you can see it's because a lot of company, when they using Hong Kong data center, from one perspective, they are worried about national security law, right? So this is one of the concerns from their perspective. So compare with Hong Kong and Singapore, of course, and we wait and see, is there any preferential treatment between China and Hong Kong under the one country, two system, right? Mechanism we can see. But I think we do see there's strong competition from another country like Singapore, right? So we need to do something to change this kind of situation from country perspective.
Right. Did TikTok move its data center to Singapore? Right.
Yeah, yeah. So there's a lot of movement.
Right. So how can Hong Kong establish itself as like a international data hub? We are an international financial center, and Chen, you mentioned that Hong Kong already have a lot of data business there. A lot of data business there. I mean, given what it is, given the the national security concern, the geopolitics, realistically, what do you think the mainland government and the Hong Kong government can do to at least achieve better harmonization, or like what Sandra described, interoperability between the two systems?
Yeah, I think it's very important to, from our perspective, we will see maybe just to formulate a cloud first mechanism, like I discussed, right? So like Richard, Mark, and Sandra mentioned. So to really establish some kind of treatment between Hong Kong and China, and we will just, this is very important for the cloud service provider. Yeah.
Right. Mark or Sandra, would you like to weigh in?
Sure. Yeah, it's a good question. And I guess in terms of Hong Kong's ambitions as a data hub, look, I think you pointed to TikTok as an easy example in a way where I think in certain sectors that ambition of Hong Kong being a data hub is a foregone conclusion that it won't be. And it's not that these organizations are intent on violating the national security laws, just they have concerns about user-generated content, for example, that could. So in certain sectors, that is just a very practical risk, which those organizations will not take. But more broadly, I guess, and more optimistically, you look at the economic unit of the Greater Bay Area, and again, I mean this in an economic sense, the potential of that unit is extraordinary. And as Sandra mentioned, the free flow of data in areas such as transaction monitoring, money laundering, playing to Hong Kong's strength as a financial hub. And that is still a strength. That's I think, recognized by all, even when we're competing against Singapore and Japan. And I think, playing to that sort of strength, I think I would be focusing on then having, I'm a believer in standards-based regulation, because what we have, particularly in this context, and these are personal views, we have this significant uncertainty around regulatory intention. We don't quite know what are the policies behind this, what is important data, what is critical. It could mean one thing one day and something else the next. Well, I think the only practical answer for clients who are reading this, trying, well, how do we plan our business? Where do we put our data center? What do we do? Is a very clear standards-driven mechanism, which then prescribes, oh, here's what you do in very specific terms. You need this level of encryption and this level of, and that way, it just brings much needed clarity. It goes back to my point I made earlier. I think lack of clarity is a huge, huge challenge here. And again, if the focus is being a financial hub, a fintech hub, digital banking hub, and I think that really is playing Hong Kong's strengths. This is an area where very typically the industry has been very standards driven. And I think turning to Chen's point about cloud and having, and I think part of what is the solution there, actually, then, well, you recognize these standards, and that way the cloud industry, they have standards, and the banks have their standards, and we have these standards, and that way we can just focus on something very literal and easy to understand and follow, rather than having to worry, I think, about wider policy challenges that are very difficult for organizations to understand at a practical working level.
Sandra.
Well, I think law gaps and things like that, uncertainty. Yes, I agree with Mark that the standards and that will help us to a lot of extent, because when we look at flow of the data between jurisdictions, it's not just about the data law, but also the technology standard as well. So ISO standard, what does it mean? And when you compare with the MLPS, etc., whether a soft report can be considered as an attestation and audit basis and to be accepted by the China side. So a lot of these going forward will be an area of exploration, standardization, certification, and things like that. So one way which the perhaps we can consider in here in Hong Kong is whether you accept some of these standards as not just good practice, but perhaps being recognized as something that we should put in place when we look at the technology standards, et cetera, et cetera. Another point about how to position Hong Kong, I believe that when we look at the digital policy and digital economy, it's not just about the infrastructure, it's also about the soft component, that is the talent, the people here, whether we have the awareness, we have the sufficient knowledge to build the accountability and awareness within organizations that make this sort of framework work. So I think we have to look at it from a hardware perspective and also software perspective. I think that part of it we haven't explored too much, but I think it's a key thing that we need to consider as well.
Right. Look, I mean, a lot of the audience here today are students, and one key question they want to know is there a lot of business in the data practice these days? I mean, Mark, maybe I can ask you first. I mean, did you see an explosion of workloads in the past 2 years?
Yeah, I think you're choosing well in terms of career planning. It's so my background, I started out as a technology lawyer where I really just focused on negotiating commercial agreements. I got into data regulation because I realized my clients wanted me to, when that started becoming a thing, my clients wanted me to understand that so I could negotiate around those issues. And flash forward now, and we've got, part of my team is full-time dedicated to data. It's now a practice in the way that it wasn't when I arrived 15 years ago. So, looking, it's taken time. I think it's taken longer than people expected to take off here in the region, particularly. But with PIPL, the game changer with PIPL is organizations here in the region now have a very, very good reason to adopt sort of the GDPR program, which is a lot of work. It's lots of spreadsheets. It's lots of analysis. It's writing policies, evaluating, conducting privacy impact assessments. All of these things that have to be done to comply with that law are now much more reality here in the region than it was even 5 years ago. I think the last few years there's been a real uptick in this, and that will carry on. So if you're studying now and looking for a career in the area, I think it's a very auspicious time to be studying what you're studying.
Well, let me ask Sandra, because you graduated from here. Did you take any data law while you were here? How did you learn your data practice?
In my day, I think we're not that advanced. I mean, in terms of courses, we don't have data courses, but it would be a good course and subject to take because that you can see real prospect of monetizing data. It means a lot of things. The analytics, the insights that can be generated from even publicly available data can mean a lot. So don't just look at the personal data side, because there are lots that's happening on the data side, non-personal data side, and also how do you relate to intellectual property, a database rights, etc. I can see real potential if we can look at the circumstances, not just like Mark said 5 years ago, maybe even 2 years ago is different. So, but one thing about having formalized and better recognized courses in Hong Kong, another point is about, do we recognize the profession under the law? I mean, we have the appointment of DPO in EU law and UK law and the people as well, but we don't have that in the PTPO. Is this something that we should think about? And also the accountability principle is not well explicitly established under the law. So I think there are lots of things which make the profession work, but honestly, this is something which I haven't thought about a few years ago. But this is, I think, a very good development for Korea. But honestly, it's not just about the law. It's not just about interpretation of legal provision. It's about operationalization, implementation, and pragmatic solution. So when you build a team, it's not just lawyers. Sometimes it's about data scientists, data management practitioner, etc. So compliance side and lawyer side all work together.
Great, fantastic, and thanks for giving me, helping me to promote my course to the students. Thank you. Now let me open up the floor for Q&A from the audience. We have about 8 minutes left, so take the opportunity. Yes, Susan. Susan, would you like to introduce yourself? It's okay. Even if it doesn't work, we can hear you.
Oh, yeah, I'm Susan Pinder. So distinguished scholar and resident at the Peking University School of Transnational Law, fellow here at the law faculty. So my question concerns, so Hong Kong is the International Arbitration Center. So what does this all mean for Hong Kong's very important place as a place for arbitration?
But with Susan in her last life is a practitioner with pressure. Any of our panelists would like to take that when it comes to arbitration? No?
Well, I'll give it a go. It's not something I think I've given a lot of thought to. I can see interesting arguments coming up around disclosure on Sino-foreign disputes, whether or not it's permitted to make that disclosure. There are other features of the data security law that prohibit Chinese companies sharing data with regulators, law enforcement. So again, that may be invoked to resist disclosure orders, things like that.
Yeah, there's provision in the PIPL in terms of the legal proceeding, particularly.
Yeah, but again, we're not just talking about personal data. In the context of an arbitration, probably less so. So those are possible implications.
Right. Yes, Dean, following.
All right, thank you. We're talking about important data, core data, national security. So China has another legal regime that is the state secrets. We haven't mentioned that. And how do the two regimes speak to each other? For example, in some of the cases about the sort of audit paper, everything is about state secrets, but now everything is about data. So
we've raised a very good question because, and just for wider awareness, state secrets law goes back quite some time in China. That's for years and years and years we've had cases around that, and we actually had a case we helped a client which was involved in an exercise of trying to understand, well, what state secrets do they have in their business? And it was the memorandum we produced for that. And this is all before cybersecurity law even. This was an exercise we did back in about 2015. And it's a memo about the thick, which tried to define what a state secret is based on, there's some industry classifications, there was a bit of jurisprudence and so on. But ultimately it leaves you with a very open-ended answer. And I think the only answer I can give to you is there probably is overlap because the state secrets regime, there are types of data which are subject to industry classification already. And I mentioned a couple of those mapping data, the data that autonomous vehicles collect, and there are specific regulations around those. And now, could it be both a state secret or a critical data? I'm sure it could. To give a real life example, we were evaluating a product for a client where there was concern that even real estate prices could be considered sensitive enough politically that, well, is there a chance that it's a state secret? And it seems extraordinary, but the problem with the lack of clarity in the law, you can't actually rule it out. And so I think the upside to what data security law proposes is industry regulators will actually go through and I think classify with greater precision what data is sensitive and which is not, and of course which is core. But we're, as Richard mentioned, we're very early days on that. There are a few industry regulators who have started that cataloging process that we're aware of. That sounds like a mountain of an exercise to do. So we're a long way away from that. But I actually think it probably would be better to have that sort of regime rather than an open-ended state secret regime. But that said, it's an open question as to whether the Chinese authorities would view having a closed set of categories would be sufficient for their purposes. And I think the feeling would be no. And so I think we're always going to have a state secret regime. We'll have classification under DSL. We'll have industry regulators doing their own classifications. It's going to be very messy.
We all see, right? I mean, it is a really difficult topic. We have a lot of challenging issues, but I think they also present a lot of opportunities for our students here. Right? I mean, a lot of business, a lot of hours, right? A lot of money out there. So too many. Okay, yeah. So come and take my course. Okay, and it takes not just me, my effort, and I also want to draw in the talents on this panel. Here, if you have time, come and drop by and guest lecture in my class. It takes a village to teach this class. This is extremely difficult, and I learned a great deal from you guys today. So thank you all. And we have the next panel coming up soon. Now is the tea break. Okay, thank you.
Thank you.